In class, we have been discussing the areas that fall under the practice of law that non-licensed attorneys should avoid, and areas that are of particular concern to paralegals because you are likely to be in a situation where you may be faced with some of those issues. This video is going to look at specific activities that are allowable for a paralegal to be engaged in, and also some activities that are considered to be more gray areas that may not be clearly UPL. But here at the Paralegal Studies program, we do encourage you to use extreme caution and avoid these situations because it can open you up to a situation where you may end up engaging in the unauthorized practice of law, even though that may not be your intent. So first, let's look at some of the activities that are generally not UPL. Now, this is working under the assumption that you're working for an attorney, the attorney is appropriately supervising you, and the attorney has delegated this work to you, and the attorney still maintains control of the work product, meaning the attorney is going to be appropriately reviewing your work. When you look at this list, and this list is also in the textbook, but when you look at this list, it should seem very familiar to you because a lot of what is on this list are the things that we cover in the classes that you take in this program. So conducting both legal and factual research and investigations is generally not considered UPL. Drafting memoranda, pleadings, and other legal documents, including discovery requests, also not considered UPL. Notice it does use the word draft. That means you are doing the initial drafting, you're giving it to the attorney to review, and then the attorney is going to make any changes or authorize it to be sent out. So they still have control of the work product. Preparing standard form documents, whether a subpoena or an affidavit, something along those lines. Correspondence for either your attorney's signature or your own signature. It is completely appropriate for an attorney to delegate letter writing to you for you to sign with your own name. If it is a situation where there is a lot of legal advice being given or any legal advice being given, that usually goes out under the attorney's name. Even though you may be drafting the letter, the attorney is going to review it and either sign off on it or give you the okay to sign off on it on their behalf. But there are a lot of letters that you could be writing on your own behalf, sending copies of documents to the client with a cover letter, requesting documents for them to provide to you. So a lot of the correspondence can go out under your own name, again, with the attorney's permission. Interviewing clients, witnesses, and acting as a liaison between the attorney and those outside the firm. That again is never an issue. Obviously, one of the concerns with that, though, is going to be, especially with clients, that they're sometimes going to ask you questions that may require you to give legal advice. And if you are ever faced with one of those questions or think they're asking you for that type of information, it is better to just tell the client that you will ask the attorney and one of you will get back to the client as soon as possible. Organizing, analyzing, summarizing legal documents. So all the paperwork, photographs, bills, whatever is coming into the office, that is certainly something that paralegals can appropriately handle. Filing documents with courts and government agencies, any sort of internal administrative or scheduling matters that need to be taken care of. You are, as we've already talked about, you can always relay attorney's advice to the client. So if the attorney says, tell client that they need to do this, or this is the answer to their question, that is never going to be a problem. And assisting the attorney in the trial prep, which could involve prepping the client, prepping the witnesses, getting the exhibits in order, putting together trial notebook, assisting the attorney at the trial. All of that is completely appropriate. So again, a lot of those are the types of activities and assignments that we cover in our classes here because that is typical paralegal type of work. Now the gray areas, these are possible UPL activities. So again, we would strongly encourage you to avoid these situations because of the reasons that we're going to be talking about. And I think it would be unlikely that an attorney would put a paralegal in this situation, but sometimes things do happen. So you just want to be aware of what the issues are. So if you are faced with them, you can take appropriate action. And again, always keeping in mind that we want to avoid the unauthorized practice of law to protect our clients first and foremost, but to also protect our attorneys and to protect yourself. You want to hopefully have a long career in the legal field, and you don't want to get in a situation where you are either making bad decisions or being told to engage in activity that you shouldn't be in. So one gray area is the will execution. Now, the will execution is the last step, as you know, in the drafting of the will and estate planning documents. As a paralegal, you can meet with the client, you can gather information, you can draft the documents, you can witness the documents, you can sign as a witness on those documents. If it's a document that requires a notary and you're a notary, you can do that. However, the actual supervising the execution of the will, being the person that meets with the client when the client comes in to sign that will and when the witnesses sign that will, that can be UPL. And the reason it can be UPL is if that client shows up and has any questions, wants to make changes, needs clarification, those are the types of questions that get into asking you for legal advice. If you are the only person there that can deal with that, you are put in a very difficult position. At that point, you either answer their questions, which means you are engaging potentially in the unauthorized practice of law by giving legal advice, or you are telling them that you can't answer those questions. And if the attorney is not there, then you have to send the client home, you have to reschedule the will execution. You're going to have an unhappy client. They're going to be frustrated. You're going to get the brunt of that from them, unfortunately. It's just a bad situation to be in. And quite honestly, from a personal standpoint, if I'm paying the attorney to do this work, and typically you meet with an attorney twice when you go through this. You meet with him the first time, setting up everything you want. You meet with him again when you come in to sign the documents. I think an attorney should be available. I think it is the appropriate thing to do and the proper thing to do, and it's a very professional part of the job. But if you ever have an attorney say, I'm going to be out of the office, but client's coming in to execute their documents, you might want to ask a few questions, such as, what if the client shows up and has questions? What if they want to change something? What should I do under those circumstances? Or, where can I reach you should that happen? I think sometimes we get fooled into thinking there won't be any issues because frequently the client has seen these documents ahead of time. We've sent them to them. Let us know if you have any questions. We don't hear from them. Everything sounds good. They come into the office. We think it's going to be fine, but no, now the client has a question. So you can't rely on the fact that you've already given the client time to review the documents and assume that when they show up, they're not going to have any questions or concerns. So that is the issue with the will execution. Real estate closings or settlements is another situation, and it basically is very similar. Your will and estate planning documents are not valid until they are executed. So even though we might look at the execution as the formality, it is the step that gives them legal validity. It is in many ways the most important step. Same thing with the real estate closing. By the time everybody gets to the closing, it seems like it's more formality. You've already gone through all these other steps, but it is the same type of situation. If you are at a real estate closing representing a client, if the client comes in or if the other party comes in and issues are raised, concerns are raised, clarification is needed, and you as a paralegal are the one sitting there, you are put in a situation where you're likely going to have to give legal advice when you shouldn't. And yet your options are to try to answer the questions and offer clarification, or make everybody wait while you try to get a hold of your attorney. And if you can't do that, having to reschedule the closing. Nobody's going to be happy. Everybody's going to be looking at you very frustrated, very disappointed. You don't want to be in that situation. So again, as a paralegal, you can be involved in, meeting with the client, interviewing the client, gathering information, drafting documents, You can certainly attend the closing, but if it is only you attending and you are attending as the representative of the client, that can be problematic. Now, if you happen to be a real estate agent and you're there as a real estate agent, that's not an issue. So we're only talking about a situation where an attorney is representing the party in the actual real estate transaction. So, you can be a real estate agent and be there. You can be a settlement officer and obviously be the one handling it. So there are other areas where you could appropriately be there and be able to answer questions. But if you are working for an attorney, the attorney is representing the client in this matter, and you're showing up on behalf of the attorney, that's the situation that can become a gray area. So that is the main concern with real estate closings. Pennsylvania does have an advisory opinion that states that legal interpretation may need to occur at closings, and only the attorney can provide that. So if there is an attorney assisting a client in that transaction, the attorney really should be the one that is at that closing with the client. And again, like the will execution, the real estate transaction is not complete until this closing occurs. So even though there's been an exchange of information and a review of documents and the ability to ask questions ahead of time, if there is an issue at the closing, you can't close. It is a critical step in the process. So that is a concern with that particular area. The third area is dealing with any sort of settlement in any type of case, whether it's the negotiation aspect or the offer or the acceptance. So just a bit of a reminder, because we do talk about this usually in civil litigation too when we talk about settlement, is that even an attorney needs to consult with his or her client before making or accepting an offer. So unless we've already talked to the client and they said they've given their okay to accept an offer or make an offer, we can't accept it. We always review it with them. It is up to the client whether to accept it. We can certainly encourage or discourage them as we feel is appropriate and in their best interest, but we cannot make those decisions without them. Depending on your role in a particular case, you may be the point of contact frequently with the opposing party or with the insurance company, whoever it happens to be. And so the offer may come in to you. And if that does happen, you cannot accept it unless your attorney has given you specific instructions that if this specific offer comes in, you can tell them yes or no. You cannot accept it. You cannot tell them whether you think it's a good offer, whether you think your client will accept it or not. You just take the information and you relay it to the attorney. The attorney will then talk to the client. Sometimes offers come in with very tight deadlines. You need to get the information. You need to tell the other party that, if the attorney's out of the office, you will be contacting them as soon as possible, and one of you will be getting back to them. But you don't want to become involved in that particular process other than to relay the information back and forth. It does, this is a critical step in trying to resolve the case. And although you may be involved as a paralegal in the development of the case and may be just as knowledgeable what a good offer to make or accept is, you leave that up to the attorney and you just share the information with the attorney who will then discuss it with the client.